So after you're arrested in South Carolina, you're going to have a bond hearing within 24 hours of your arrest, guaranteed. It's not if you get a bond hearing, you're going to have a bond hearing within 24 hours of arrest. Now, depending on what your charge is, depends on whether bond can be set, what they call a bailable offense. So as long as your charge doesn't carry life imprisonment as a maximum penalty or a capital punishment, it's a bailable offense. Now, a judge could still deny bond on a violent offense under the law, but everything else is going to be eligible to get a bond. The magistrate court judge, the summary court judge that's reviewing the case must set a bond on a bailable offense. Now, for a bond hearing, there's two main factors that a judge is going to be looking at. Whether the bond amount will reasonably assure their appearance in court. Are you a flight risk? Are you going to flee from prosecution? You're going to run away. Or whether your release would pose an unreasonable danger to a specific person or the community. And remember, it's that higher level, that higher burden of an unreasonable danger. Now, you're already presumed innocent of the charge, but there's several factors under the law that we need to look at, whether you have strong ties to the community, your prior record, the nature of the offense. All these things that the judge is going to take into consideration with those two main things is flight risk and unreasonable danger to the community that the judge has to show. Again, a bond can be denied on violent offenses, but that's the difference there. Everything else is a bailable offense, and a bond must be set within that 24 hours. Now, once your bail is posted, the jail, the detention center must release you within 4 hours of when that bond is posted. And that's a very critical point. So again, 24 hours of arrest, you're going to have your bond hearing. Once that bail has been posted, 4 hours, you should be out of the detention center. Now, after you have your bond hearing, what's generally said is a first appearance. Then they also will have a second appearance. Now, a good lawyer is going to immediately file a letter of representation and a motion for discovery, requesting that the prosecutor provide them with every bit of information and evidence they have against you so that he can then review it and provide the best defense possible. A critical point with the first appearance is that you better have a lawyer. You ultimately, if you're not able to afford one, you can be screened and appointed ultimately if you qualify for a public defender. However, if you have the financial ability, you need to hire a lawyer as soon as possible. The best defense begins on day one. The evidence can be lost, destroyed. There are things that need to happen immediately. So you don't need to wait till your first appearance before trying to find a lawyer. You need to hire a lawyer absolutely at the very beginning, a point of arrest. And obviously, if you knew you were under investigation, you need to hire a lawyer at that point. There's no need to wait. You can't put your head in the sand. You need to have a lawyer to protect your rights from day one.